Good morning.
Good morning. Chairperson Liebman and members of the board, good morning again. My name is Elizabeth Bunn, and I'm the organizing director of the AFL-CIO. I speak today on behalf of President Richard Trumka, Secretary-Treasurer Liz Schuler, and Executive Vice President Arlene Holt-Baker, as well as of our 55 affiliates who represent over 12 million workers throughout the United States. Prior to this position, my background includes working after law school in the Enforcement Litigation Division of the board, and for 25 years working as a staff person and then officer of the UAW. While there, I oversaw the union's organizing activities in non-manufacturing. The AFL-CIO urges adoption of the board's proposed rule. It will make a positive, albeit modest, difference in the workability and efficiency of the NLRB's election process. The Act's purpose is to encourage collective bargaining and to protect workers' rights of full freedom of association. This is our national policy. It is also a right enshrined in the United Nations Universal Declaration of Human Rights. It is a metric that determines whether a political system falls on the side of democracy or tyranny. There are benefits to fostering this statutory purpose. For one, as was said yesterday, individual workers, employers, and neighborhoods prosper. Let's not forget, the road to the middle class was paved by strong unions. Additionally, while we all have an economic stake, we are also stakeholders in upholding the principles of fairness and democracy. Under the current rules, the board is hamstrung from fulfilling its mission of protecting workers who seek an election to form a union, to exercise their full freedom of association. The truth is that employers are able to exercise too much control over the timing of the election. One clear example is bargaining unit challenges. In his book, Confessions of a Union Buster, Martin Levitt states, and I quote, "The beauty of such legal tactics is that they are effective in damaging the union effort no matter which side prevails," close quote. He goes on to cite a challenge on unit size, which was, quote, "filed 2 weeks into the campaign, and the case took at least 3 weeks to resolve. That kind of delay steals momentum from a union organizing drive," close quote. Being able to influence timing and delay, the employer is able to implement its own campaign timetable. All too often, employers illegally discipline workers, hire unscrupulous consultants, force employees to attend group and one-on-one meetings, and sometimes even threaten to close the plant. The goal is not to inform. The goal is to harass, delay, confuse, and intimidate. The toll taken on individuals is immeasurable. You've heard worker stories during this hearing. There are thousands of others. Here is one more. One of the workers in a drive among table games dealers at an Atlantic City casino was an immigrant from China. He became disillusioned by the Communist Party, in part because it had denied him permission to marry the girl he loved. Courageously, he left the country and emigrated to the United States. He fell in love with our hopes, our ideals, and most importantly, our commitment to liberty and democracy. When he and a majority of his co-workers decided to file for a union election, he was confident that his government would protect his right to vote through a fair process. Instead, he and his colleagues suffered through delays, frivolous litigation, countless mandatory meetings. The workers showed amazing resilience, voting 2-1 in favor of the union. Workers won, but it should not have been so hard. He expresses disappointment and sadness by the unfairness of the process. He feels that his government, our government, failed him. And it did. When the government holds out the promise of a fair election, it should deliver on that promise. We know the board's proposed rule is not going to fix all the problems and abuses faced by workers in the representation process, but the proposed rule does take a small step in addressing some of them. It puts a check on unproductive litigation, thereby making the process more efficient. It enhances the ability of workers and their unions to communicate timely with one another through the means modern technology has created, fostering the democratic tradition of robust debate. It modernizes the way we do business. It creates greater certainty and uniformity in the election process, better enabling the board to prevent gamesmanship. It enfranchises voters by removing the Hobson's choice unions currently face in stipulating to elections. Under the status quo, the employer is able to hang a sword of delay over the union. The employer can insist on a bargaining unit to its liking, in my experience defined as one in which it thinks it can win. Union supporters must stipulate to that unit or face delays. When unions choose to stipulate against their legal judgment, workers are included who should be excluded, and vice versa. Appropriate voters are disenfranchised. Under the proposed rule, at least some eligibility questions are deferred until after the election, just as in political elections, by the way. Other disputes are resolved more efficiently. May I have a minute?
Yes, please.
Consequently, that Hobson's choice is avoided. The AFL-CIO and our members will continue to press for more holistic and comprehensive solutions to the problems that plague the NLRA. Today, we support the board's proposed rule and urge prompt adoption of these modest reforms. Thank you.
Thank you for being here with us today. Anyone have questions? I have a question for you. As the prior speaker, Mr. Weinrich, mentioned, unions are treated under the law as having only the derivative rights, not the direct rights that employees have. So therefore, unions don't have a right of access to the employer's property. What is the way that you typically communicate with workers, and would the provision for adding email addresses or telephone numbers, or would that help, or what is the way that you find most useful for communicating with workers, and does that vary according to the type of industry or the type of worker?
Right. It obviously varies to some extent depending on the access to the employer's property. But the imbalance between the ability to communicate by union supporters with one another and by employers to their employees is one of the great imbalances of the process, and one that the board specifically does not address by its rules. But the way in which workers wanting a union overcome this is to talk with one another off work time, off work property, typically. And the problem with that was discussed yesterday to some extent. That means driving to workers' homes, trying to get people to come to a coffee house or what have you. And all of that information about addresses is just compiled from one worker to another worker. Allowing for email addresses and phone numbers obviously brings the board into the 21st century, because that is the way in which people communicate more and more, as you know. But it also provides an ability for union supporters to communicate with one another more easily.
I don't know if you yesterday heard some of the complaints about providing email addresses that would raise privacy concerns, and some employers said that they're unaware of the fact that their names and addresses could be given out to a union, and would be upset to learn that their email addresses or phone numbers were given out, and that maybe some consent procedure. What do you find, or what is your view about that argument?
Yeah, that's not been my experience doing a lot of organizing drives over the years. Typically, we find that workers actually prefer to talk to union supporters and their union representatives off work, because it's in an environment where the fear at least is taken out of the communication. So we've not experienced that anger and irateness that was discussed yesterday. To the extent that workers feel anger, I think they feel much more so about being hauled into captive audience meetings and one-on-one meetings where their voices are silent and where they're not allowed even to state an opinion on threat of discharge.
Yes, Member Pierce.
There have been statistics mentioned by several during the presentations yesterday regarding well, 90% stipulations on petitions, and over 60% win rate with respect to cases that have gone to elections. Have you experienced the negotiation of stipulations, and if so, what kind of considerations you find have to be made?
In my own personal experience, that mirrors the experience that John Brady talked about yesterday with respect to the Bacchus Hospital, which is that the employer comes in, insists on a certain bargaining unit, one in which it believes it can win, and literally holds a sword of delay over the union's head and threatens to litigate up to and including the Supreme Court is generally the phrase. And so unions are, again, faced with this Hobson's choice of stipulating or face lengthy delays. And oftentimes, unions choose to accordingly stipulate, even if the unit really does not, in its opinion, meet the tests of appropriateness. And I think one of the beauties of the rule, and I probably didn't say this very well, so let me try again. I think one of the beauties of the rule is by delaying some voter eligibility questions to after the election, where those workers will vote under challenge, but also making to the extent that there are issues that need to have a hearing pre-election, making that process more efficient, I think puts a much better face for both parties on whether to stipulate or not.
Can I ask one more question? You've probably heard a number of people express concern that these rules might decrease the number of stipulated elections because the employers wouldn't have time to kind of figure out their legal position and would then just put all the issues down and litigate much more. Do you have any reaction to that? Do you have any thoughts? Do you have any fears that that would happen?
I don't have any fears that would happen. It is sadly accurate, I think, to believe that there will be anti-union consultants who will attempt to manipulate the new process. But the beauty of the new process is that it keeps control over the process much more in the hands of the board's decision makers.
Any other concerns about the rules, that they might have unintended consequences?
I didn't answer Member Pierce's second part of his question about elections. Those statistics about win rates, and I've heard different numbers throughout the last day and a half, but those are petitions that go to election. There are a number of petitions that are withdrawn prior to the election because of the abuses in the current system that have been discussed throughout the last day and a half. So I don't think that just looking at that one slice of the data pie gives a full picture.
Thank you.
I just have one question. That is, of the options with respect to blocking charges that are suggested in the notice, are there any of those options which you believe to be preferable?
I'm not familiar with the precise options, but let me say more generally, and we will be submitting, by the way, written comments. With respect generally to blocking charges, I think one of the earlier spokespeople said it best. We're trying to effect here a fair election. And by definition, blocking charges suggest that there cannot be a fair election. So the idea that they would not be permitted and you'd have an election where it was the laboratory conditions had been, by definition, destroyed, doesn't make any sense to us.
Well, that, of course, presumes that the charge itself had merit.
That's true.
Thank you.
We don't file on meritorious charges, sir.
Thank you, Ms. Bunn, for being here with us today and sharing your thoughts.
Thank you.